I'm gonna grab some water really quickly, but I have this on audio, so if you need anything, just speak up and I'll run right back.
Yeah, I'm gonna do the same right now.
Perfect.
Okay. All right. And then also video. I don't see video.
Oh, Jimmy, welcome.
Okay.
There you are. Hey. Oh, you look nice.
Excellent.
Class.
Thank you. Thanks. Yeah. Hi, everyone. Good morning.
Good
What's
morning.
new? So wait, Bob, what's new? What happened?
Well, we're doing. Carol's going to first cover the Maui case and the Weyerhaeuser case, and the WOTUS rule, and then we go to our PowerPoints that we put together.
Okay.
All right, and then really quickly, Jimmy, I just gave you control over the slides. So if you can just click the PowerPoint as you see it, you can then use your arrow key, the right arrow key to move forward or the left arrow key to move backwards.
Okay, so I don't see the arrow keys, should I?
So the arrow keys
Oh,
on your
here.
keyboard. Yeah, on your own keyboard.
Oh,
The up
gotcha.
and down button on your keyboard.
Mhm.
Okay. All right, well, good morning, Carol. Thanks for doing this, or good afternoon.
And he cautioned us that only one of us should be clicking this at the same time or we're going to have problems.
Right.
Yes, if you do lose control of the slide, all you need to do is re-click it. That's the only thing to be aware of. And also, if for any reason you prefer me to control your slides, just please let me know and I'm happy to do so.
Okay.
And
Well,
I did,
I'll be introducing both of you as soon as I finished my slides.
I did reconfigure one aspect of our slides, Jimmy. The court this morning granted the Biden administration's request to GVR the Biden versus Sierra Club case. And the press is already erroneously reporting the court has declared that the border wall construction was legal, which is not the case at all. And that this was a blow to the Biden administration, which was not the case at all, because they asked for this. But I put that with cases that they're hearing this year, because it's like the first order of their term. And
Okay.
what it was that the Biden administration said, we've declared the national emergency's over. We're not spending any more money on any border wall. So it's best that you just vacate the previous judgments. And that's exactly what the court did.
Okay. Interesting.
And
Any other?
They
Yeah, go ahead.
didn't say anything about the Affordable Clean Energy Act or the Clean Power Plan rule, but they didn't deny cert in it, and they had considered other cases at the same time. So something's going on there. My theory, unlike Richard Lazarus, my theory is that what's going on is that they take at least two conferences before they grant review and such a thing.
Yeah.
But
Okay.
could also be, he could be right that one of the conservatives is writing a dissent from the denial cert.
Right. Well, I see the time is 12:02. Are we feeling ready to get started?
Sure.
The thing.
Perfect.
Right,
All
go
right.
ahead again.
If you don't mind to keep yourself on mute while you're not speaking, that would be great. But I'm going to go ahead and get us started now. I'm going to give folks just 1 minute to get in. I see they're starting to come in now.
How many?
We had over 400 registered, and I'm seeing 150, 160 now, 170 on. I would anticipate about 200 folks on the line. All right. Well, I'm going to get us started. It started to slow down. Good afternoon and welcome to the 2021 Annual Supreme Court Review and Preview. My name is Chandler Randall and I am the Manager of Educational Programs here at the Environmental Law Institute, and I am so delighted to welcome everyone to today's program. ELI is proud to offer programming on cutting-edge issues in environmental law and policy, and it is such an honor to have you join us today for this special program. Throughout the program, we will be taking your questions. Please submit your questions through GoTo's question box, and please do not wait until the end. Send in your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their expertise to this webinar. And while they will be introduced briefly, the full speaker bios are posted on our website, eli.org, and I encourage you to check out their expertise in more detail there. But as we begin, I would like to briefly introduce today's moderator, Carol Miller. Carol J. Miller holds the rank of Distinguished Professor at Missouri State University, where she teaches environmental law and business law. She is a licensed attorney with her JD and MBA from the University of Missouri-Columbia. I will just pause for a moment and give a shout out. That is also my hometown, so it's great to see that there. After law school, she clerked for J.P. Morgan, the Chief Justice of the Missouri Supreme Court. Professor Miller is the past president of the National Academy of Legal Studies and Business, from which she also received the National Excellence in Research Award. She has written over 100 articles and received over 30 research awards or fellowships, including the Women's Justice Legal Scholar Award from the Missouri Lawyers Media and a Best Article Award from the Journal of the Missouri Bar. Recent awards include the Missouri State University Foundation Research Award and Public Affairs Award for contributions to environmental issues. Her recent environmental articles were published in the University of Virginia Environmental Law Journal, William and Mary Environmental Law and Policy Review, the Vermont Journal of Environmental Law, and the ABA Natural Resources and Environment Journal. Thank you all so much. And with that, I will turn things over to our amazing moderator, Carol Miller. Thank you all so much.
Hey, Chandler, I'm having difficulty getting the slide to advance. There we go. I'm going to be looking back before my co-panelists look forward on some of the things the Supreme Court has done with regard to updating a few issues related to the Maui decision, the Gopher Frog case, and the WOTUS definition. Chandler, the slide's not advancing.
Carol, if you just re-click the PowerPoint, you should be able to take control again. Or I'm happy to control it for you.
Well, I'll go ahead with this first slide. I'm not seeming to be able to advance slides. The purpose of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. And as Justice Stevens said in his dissent in the famous Rapanos case, the congressional intent in enacting the Clean Water Act was clearly to establish an all-encompassing program of water pollution regulation. In passing the CWA, Congress emphasized that it is essential that discharge of pollutants be controlled at the source. I'm not able to advance to the next slide. In the Hawaii Wildlife Fund case versus Maui, the key issue before the court was whether or not a Clean Water Act permit was required when pollutants originate from a point source but are conveyed to navigable waters through an intermediary such as groundwater. In that case, the pollutant was the municipal wastewater. The point source was the injection well, and the navigable water was the Pacific Ocean. Next slide. Over 4 million gallons of sewage per day were injected in these wells, and about 2/3 of it ended up in the Pacific Ocean. Next slide. In looking at this jurisdictional issue and writing for the majority, Justice Breyer established a new standard. A Clean Water Act Section 301 NPDES permit is applicable to a discharge from a point source of pollutants that reach navigable waters after traveling through groundwater, if that discharge is the, quote, functional equivalent of a direct discharge from a point source to those navigable waters. Next. In establishing this standard, Breyer didn't want someone who owned a pipe to be able to put it just a few feet above the navigable water and avoid having to get a permit. But he also did not want to require a permit if it took a great distance or a great length of time for the pollutant to reach navigable waters. So in establishing this standard, he also put forth a 7-point test. Next. And of these 7 points, the transit time and the distance traveled were the most important. But he also asked that the courts look at the extent to which the pollutant was diluted or chemically changed, in considering whether or not this was the functional equivalent to a direct discharge. Next. In January of this year, in the last week of the Trump administration issued guidance in a memorandum, adding an 8th point to those 7 factors. And that 8th factor was the design and performance of the system of facility from which the pollutant was released. On September of this year, the Biden administration EPA rescinded that Trump guidance, saying that the Maui decision focused on whether the permit is required to protect the surface waters, not on the protection of the groundwater itself. And the existence of the state groundwater protection programs does not obviate the need for an NPDES permitting. The EPA will apply site-specific, science-based evaluations of whether the discharge from a point source through groundwater reaches the jurisdictional surface water as the functional equivalent of a direct discharge. Next. This, besides the majority opinion, there was a concurring opinion and 2 dissents. In Kavanaugh's concurring opinion, he cherry-picked several quotes from Justice Scalia's 2006 Rapanos opinion and referenced the following, which was dicta in the Rapanos case. A discharge into an intermediate channel of any pollutant that naturally washes downstream likely violates the Clean Water Act, even if the pollutants discharged from the point source does not admit directly into the covered waters, but passes through conveyances in between. And Justice Kavanaugh selected this and several other quotes from the Rapanos decision, which did not itself address conveyances or intermediate sources through which the pollutant had to travel, to justify his concurrence with the majority opinion here. Next. In the dissents of Thomas and Alito, they took a much narrower construction of the Clean Water Act, stating that only a direct discharge from the point sources directly into navigable waters would require a permit. They used textualism to point out that the Clean Water Act literal text doesn't include anything from which the functional equivalent standard could be derived. They also believe that the standard impinged on federalisms and the state's traditional authority to regulate groundwater. Probably more important, they thought that the standard was too nebulous, and a number of individuals have criticized it for this point. It adds great uncertainty, costs for businesses, and insufficient guidance for lower courts because of the somewhat vague criteria that is to be applied. And this could add costs, especially at the jurisdictional stage of trying to determine whether permits were required. Next. So the Trump administration, at the same time that the Supreme Court released its opinion, put forth a proposed interpretation that groundwater was not to be included in the NPDES program, regardless of the hydrological connection between the groundwater and the jurisdictional surface water. Next. In the Maui decision, in this hydrological connection discussion evolves back to the concurring opinion by Justice Kennedy in the Rapanos decision in 2006, where you look at flow and characteristics and function of tributaries to determine the significant effect on chemical, physical, and biological integrity of downstream traditional navigable waters to link them together in a hydrological connection. Next. The Supreme Court rejected the traceability standard of the Ninth Circuit, somewhat ironically, because it also included a functional equivalent portion in the traceability of a point source to a navigable water if it was the functional equivalent of a discharge into navigable waters, and did not adopt the hydrological connection approach of the Fourth Circuit either. Next. Next. So this brings us then to a broader view of the Clean Water Act. We've had throughout this century many attempts to redefine what the waters of the US are. First, after the Swank decision, there was guidance a couple of times from the EPA, and then after the Rapanos decision, again, there was guidance in 2008 and 7 and 8, and eventually the 2015 Obama era Clean Water Rule. There were a lot of court challenges to this rule, and meanwhile, when the Trump administration came in, they eventually implemented the Navigable Waters Protection Rule on April 21st of 2020, emphasizing Scalia's approach that permanent standing and continually flowing waters were the main waters that were within the jurisdiction of the US, and rejecting coverage of coal ash ponds, and created a number of exemptions for agriculture. Wetlands, it's estimated under this rule, about half of the wetlands would be eliminated from jurisdiction. Next. There were some other lower appellate court decisions that rejected coal ash ponds as point sources, which added to the reasons for why that was in that rule. Next. The Trump administration tried to stay the WOTUS rule, and this was eventually struck down by the courts. Go ahead to the next slide. More importantly, recently, on August 30th, 2021, the Arizona District Court invalidated the Trump-era Navigable Water Protection Rule, vacated it, remanded it back to the EPA, and recognized that there were serious legal and scientific errors that would be caused if that rule were to continue. So that it needed to be revised. Next slide. So on September 3rd, the EPA and the Corps of Engineers announced that they would stop implementing the NWPR nationwide and instead would follow the pre-2015 guidance. So the controlling rule for reviewing projects reverts back in part to the Reagan era's 1986 rule plus 2007-2008 guidance that the agencies developed after the Rapanos decision, but before the 2015 Obama era rule went into effect. The EPA and the Corps had previously announced this June their intent to begin the process of issuing a new definition of the waters of the US. Next two slides. So very briefly, the Dusty Frog case that was decided in 2018 is important to the definition of critical habitat. Next. Next. All right, so the dusty frog, the dusty frog was, go back one slide. In 2001, the dusty frog was declared an endangered species. It was not until 2012 that the Fish and Wildlife Service began to set aside habitat. One of the pieces of habitat that was being set aside was Unit 1 in Louisiana, which was an area that the frog had inhabited historically, but not since 1965. This set aside was the one that was challenged at the Supreme Court. In the Supreme Court, in the Weyerhaeuser case, said that critical habitat must first qualify as habitat, and referenced the ESA that unoccupied areas must be essential for conservation of the species, and also that the Fish and Wildlife Service needed to better assess and balance the costs and benefits before determining whether Unit 1 was to be included as habitat. Next slide. Go on to the next slide. So the Fish and Wildlife Service has a new definition of habitat that was put in the Federal Register right in late December. For the purpose of designating critical habitat only, habitat is the abiotic and biotic setting that currently and periodically contains resources and conditions necessary to support one or more life processes of a species. The Endangered Species Act does have a definition of critical habitat, but not a definition of habitat. So this is being added as a regulation. Next. Also, in looking at unoccupied areas, they specified that critical habitat designation of an unoccupied area should exist only if the geographic areas presently occupied are inadequate to ensure conservation of the species, and there's a reasonable certainty both that the area will contribute to the species conservation and contain one or more physical or biological features essential for the species conservation. The Biden administration is reviewing this rule pursuant to President Biden's initial Executive Order 13990. And the Fish and Wildlife Service also this summer announced its intent to revise the rule. Next. So regulations for designating critical habitat were also in a separate regulation 2 days later, requiring the Fish and Wildlife Service to use the best scientific data after considering the economic impacts, national security, and other relevant impacts, and requires the Fish and Wildlife Service to exclude an area if the benefits of exclusion outweigh the benefits of designating that area, unless the failure to designate that area as critical habitat will result in the species extinction. So this provides a lot more protection for landowners, but some will question whether it contradicts the very purpose of the Endangered Species Act. I'd now like to introduce my co-panelists who are going to tell you more about what the court is doing this year in 2021. First of all, Robert Percival. He is a professor of law and director of environmental law program at the University of Maryland. Following his graduation from Stanford Law School, he served as a law clerk for Judge Hofstadler at the Ninth Circuit Court of Appeals, and for Justice Byron White at the U.S. Supreme Court. He also had served as a senior attorney for the Environmental Defense Fund before joining the University of Maryland faculty. He has published analysis of the papers of Justice Thurgood Marshall and Harry Blackmun with respect to the Supreme Court's handling of environmental cases, as well as a number of other articles about the Supreme Court and presidential authority. His co-panelist, James May, is a visiting professor at Quincy College of Law, University of Utah, and a distinguished professor of law and founder of the Global Environmental Rights Institute and co-founder of the Dignity Rights Project at the Delaware School of Law. He's an immediate past president and co-founder of Dignity Rights International, a board member on a number of different boards, including the Normandy Chair for Peace, the Earth Law Center, and the Delaware Green Watch. He has chaired the American Bar Association's section on Environment, Energy, and Resources Task Force on Environmental Justice, and is an inductee into the American College of Environmental Lawyers, as well as a number of other awards. He has also published 12 books, most recently The Environmental Human Rights and the Dignity of Law Handbook. He's received awards from the American Bar Association and the Sierra Club, as well as a number of universities. I'll turn it over to you, gentlemen.
All right, thank you, Carol. We have Justice Barrett, the newest justice there, whose investiture was on Friday. It's a tradition when a new justice joins the court, and even though she's already been on the court for almost a year, they held it on Friday, and all the justices but Justice Kavanaugh attended because he has tested positive for COVID, so he participated in today's oral argument remotely. Can you give me control of the slides, Chandler? Or just go to the next slide?
Yeah, so I'm trying to do so now, and it seems to not be working.
Okay, this was the first picture taken of the current court. It wasn't until April, even though Justice Barrett joined the court after her confirmation last October. Because of COVID, they weren't able to get together in person because they were holding all their arguments remotely by telephone. The next slide. This is the current membership of the court. You can see on the left there that Justice Breyer is a full decade older than any of the other justices, although Justice Thomas has served the longest on the court at 30 years. You can also see on the right that recent confirmation votes have been very close, and that Justice Barrett's was confirmed in record time, only 30 days after her nomination was she confirmed by the Senate. Next slide. And as Justice Breyer has and other justices have been defending the court against charges that it's become politicized, as they frequently note, a lot of cases are decided unanimously, but more and more now we're getting these 6-3 or 5-3 splits because there's 6 strong conservatives on the court now and only 3 liberal justices appointed by Democratic presidents. Next slide. Justice Kavanaugh has been the justice that's in the majority the most frequently. Occasionally, particularly in shadow docket cases, Chief Justice Roberts will join the 3 liberals, but it's become a much more ideologically divided court in recent years. Next slide. And that's the same chart there showed with the percentages of agreement on justice by justice basis, and you can see that Kavanaugh and Roberts agree the most on the court. Next slide. And this morning was the very first time the court has met in person in over 18 months. 8 justices were there, although I don't think Alito asked any questions, so I can't confirm for sure he was there. But Justice Kavanaugh asked questions by phone. So they had kind of a hybrid argument format. And it actually worked pretty well. They've modified how they're going to do the arguments now. They start with the opening where counsel's allowed uninterrupted 2.5 minutes. Then it's now free for all. Any justice can ask questions. And the first justice to ask a question today was Clarence Thomas. They then modified this format in order to go back to asking in reverse order of seniority if anyone has extra questions. And that led to one question from Gorsuch and one from Kavanaugh to counsel from Mississippi in Mississippi versus Tennessee, and one from Gorsuch and one from Barrett. It had been thought that that was to allow Justice Thomas who said he previously didn't get oral argument made much difference, to participate. But now I think he's going to be a regular participant, because in the first round, where it was a free-for-all, he was asking several questions. Next slide. And the nice thing is that we'll be able to hear these things live, and there's a button on the court's website that you can click now. You don't have to go to C-SPAN to listen to the arguments. So last term, there were several cases with significant environmental implications that the court decided. Let's start with, next slide, the Texas versus New Mexico case. And when this was translated to PowerPoint, the slide kind of bleeded over there. This was not due to a river, a shortage of water. It was due to a surplus of water, ironically, after Tropical Storm Odile dumped so much water in Texas and New Mexico a few years ago that it had to be stored behind the Brantley Reservoir. And then New Mexico, 2 years later, wanted credit for the evaporative losses to be deducted from the amount of water now that drought has resumed that they had to share with Texas. And the court, by a vote of 7-1, with Barrett not participating and only Alito dissenting, agreed that the river master had acted properly. Next slide. And this morning, the court granted the river master $6,000 in fees for that. This case is Florida versus Georgia. And it's interesting because these water cases, they're original jurisdiction cases, fights between states. Usually the court defers to the special master who they appoint. But in June 2018, the court, by a 5-4 vote, reversed the special master's recommendations and ruled in favor of Florida, even though special master had advocated for dismissing their case. And they essentially instructed a new special master to try to figure out if there was any way to give Florida relief. That special master decided that the real problem with the oyster industry at the end of the Apalachicola River was overharvesting and not drought, and therefore found that Florida hadn't proven that it had been harmed significantly enough to warrant the court's intervention. And in a unanimous opinion authored by Justice Barrett, the court ruled in favor of Georgia. Now, Jimmy's going to do U.S. Fish and Wildlife versus Sierra Club. Next slide.
First, is the audio okay? Just give me a thumbs up, Bob, if you can hear me.
Yeah.
Great. Well, good afternoon, good morning, good evening, everyone, whenever you're watching this later, if you're not watching it presently. But thank you again for the opportunity to talk about what's happening with the Supreme Court. I mean, so many interesting things, even what, even in the smallest details. Bob was mentioning about Justice Barrett's investiture the other day, and at least it was reported that Justice Sotomayor was the only justice who wore a mask. So that made national news. And then about the cases in the courtroom, if you haven't been to the Supreme Court, you should go. If only to walk away sort of unimpressed. It's a wonderful regal building, but it's small. And so if you attend an argument, you're among many very, very close friends, as many as 400 more or less breathing the same air. So I couldn't help but wonder, why maybe the Supreme Court didn't think about moving oral arguments to a larger venue, perhaps to engage in social distancing. But anyway, there you go. So only the litigants are allowed, the court is there, and then the courtroom artist. That's it. So I'm talking about this case, the U.S. Fish and Wildlife Service versus Sierra Club. So you may have wondered when Justice Barrett was appointed, just what would be her first case? Maybe you were handicapping it in Vegas. It could have been about due process, substantive or procedure, due process or equal protection clause, or so many of those issues. You may have been wondering, what would be the first case where Justice Barrett would write a majority opinion? If you had placed a bet on this one, you probably would have won a very handsome reward. So this is a case about a couple of federal laws, actually a few federal laws, beginning with the Clean Water Act. Yes, our old friend, the Clean Water Act. And not like what we heard earlier with the WOTUS rules, with waters of the US, but a provision 316B that pertains to cooling water intake structures. Long story short, the nation's electricity grid is largely thermal, and you need water to help keep it cool, just like the radiator in your car. And so you suck water out of the nearest water body, and it entrains and entraps an awful lot of fish, and they die. So EPA made a rule about that, and it was sued, and it made a rule in 2011, which it revised in 2013. But along the way, it engaged in a consultation under the Endangered Species Act, federal statute number 2 here. The 15 seconds on the ESA is that it requires federal agencies to consult with the wildlife agencies, the NOAA or the Fish and Wildlife Service, for any agency action that it's authorizing, funding, or carrying out. So that was here, it was a rulemaking. So when it did, the Fish and Wildlife Service kicked into gear and initially was going to issue a biological opinion that perhaps suggested that the rule might jeopardize the continued existence of some threatened or endangered species. I mean, that's part of the design of Section 7 of the Endangered Species Act, to do just that. So it issued some draft, I shouldn't use the word issue because that's to come, but it made available some working drafts. It called the draft to, in essence, find this jeopardy opinion, and it sent it to EPA. And EPA then, with this draft biological opinion, changed the rule and amended the rule in response to comments from the Fish and Wildlife Service, and came out with a new rule in 2014. That's the rule we're talking about in 2021. And so Sierra Club sued to get a hold of the earlier draft biological opinions finding jeopardy. And EPA said, no, we're not going to give those to you. Under the Freedom of Information Act, there's exemption number 5, in essence, for governmental and intra-agency documents. So Justice Barrett, writing for the court, says those are subject to the deliberative process privilege, which is one of the privileges the federal government enjoys. The documents were marked as draft, and so therefore they should be treated as draft, and so therefore they're not gettable under the Federal Freedom of Information Act. They also would not be gettable in civil litigation. Now, the takeaway on that is, as a practical matter, that would mean that biological opinions that are marked as draft by agencies are not discoverable, not subject to records production under FOIA. And at least by one account, just with biological opinions alone, out of 6,829 formal consultations, the Fish and Wildlife Service only issued 2 final biological opinions. So that would mean 6,827 draft opinions would not be subject to public viewing. So that's it. Bob, I think you have the next case.
Yeah. Okay. So yeah, next slide. This case involves the climate litigation that's going on all around the country. Cities, counties, states are suing the fossil fuel industry, and they're suing under state law, claiming basically consumer fraud, that these companies knew for long periods of time that their products were going to cause climate change, but instead denied that climate change was real, funded campaigns to stop any action against climate change. And in every single one of these cases, the defendant fossil fuel company has removed them from state court to federal court. And in all cases, except for I think one, the federal court has said the removal was improper and it should go back to state court. They've then tried to appeal the order sending the case back to state court. And the law governing review of remand orders from federal courts when they send cases back to state courts generally limits review to only two areas. One where you're claiming federal officers' removal was proper or civil rights removal was proper. And the oil companies are making a far-fetched argument that because we had contracts to sell oil to the Defense Department, that means the feds made us do this. Well, of course, it doesn't mean the feds made them deny climate change and defraud consumers, but they did find, even though all the circuit courts but one had said that the grounds for appeal are limited to those two exceptions, there was a Judge Easterbrook opinion in a case, in the Yuhong case, that nominally created a circuit split. So the court agreed to hear this case in order ostensibly to review the circuit split. Now, once they got to the Supreme Court, BP and the other oil companies said, well, you could rule on the technical issue of the reviewability grounds for reviewability of these remand orders, or what you could do is just say, you know, this is climate change. And because climate change is a global issue, it should arise under federal common law. And because the court held in the American Electric Power case that the Clean Air Act displaces the federal common law of nuisance for purposes of climate regulation, in a case where they were seeking a federal court to actually regulate emissions. Here, it's just give us damages for having to adapt to climate change that was contributed to by your consumer fraud. They said, why don't you just rule that? Why don't you just in one fell swoop wipe out all climate litigation around the country? At oral argument, Judge Barrett said that would be an awfully aggressive move for us to do that because it wasn't even really briefed or argued below. And in fact, the court did rule on the narrow civil procedure reviewability issue in a 7-to-1 opinion with Justice Gorsuch writing the majority opinion and Justice Alito recused, presumably because he still owns stock in some fossil fuel companies. The court ruled in favor of BP and said, yes, you can review any grounds for taking the case to federal court. Now, what this essentially did was, I think it bought more time for the fossil fuel industry to delay the inevitable trials in these cases that are going to make them look very bad. Next slide. Now, lest you think that it's not possible to cross the ideological divide in these environmental cases, this is the case that proves that it is possible. It's the Guam case involving a Superfund site. And the question, it's the Superfund sites in the territory of Guam. When the Navy recaptured Guam during World War II from the Japanese, it essentially ruled the island for years. And it had started the Ordo dump, or what became the Ordo dump, where it had dumped all kinds of toxic chemicals and munitions, continued to do so even through the Vietnam War, eventually turned the dump over to the territory of Guam, which used it as their municipal dump. Well, the dump started leaking, and that polluted nearby rivers, and the US EPA eventually sued Guam for violating the Clean Water Act, and the case was settled. But then when Guam, faced with having to close down this dump and spend a huge amount of money to do so, decided to seek contribution under CERCLA from the Navy for the cost of cleaning up the site, the Navy said, oh, but you settled this clean water action years ago, and that triggered the statute of limitations for bringing a CERCLA contribution action. The DC Circuit had rejected Guam's claim and ruled in favor of the Navy. But in the Supreme Court, one unusual thing that happened, next slide, is that states got together and they filed this remarkable amicus brief for 24 states, territories, and the District of Columbia. And it included 12 red states, 12 blue states. At oral argument, Justice Gorsuch remarked about this and said, you rarely see the attorney generals of these red and blue states all on the same side. They were all saying that unless you rule in favor of Guam, it's going to make it much harder for us to handle Superfund cases in the future. And the case just 4 weeks after oral argument, I covered it for SCOTUS blog, ruled unanimously in an opinion by Justice Thomas that it has to be a CERCLA settlement that triggers the running of CERCLA statute of limitations. A Clean Water Act settlement is not enough to do that. So now Jimmy's going to tell us about a couple of cases. Next slide.
Yeah, and this is the next case, which is also in some ways about a continuation of some of the things we've been talking about, which puts a smile on my face because I'm a civil procedure nerd. I teach it, and just think about these cases that you just heard about from Bob. The Guam case is about statutes of limitations. Ultimately, the BP Baltimore City case is about removal. The first case about Fish and Wildlife Service Sierra Club is about what's discoverable and what has to be turned over in their FOIA, and whether there's a deliberative process privilege that's available. And that's all just civil procedure. I don't know if that's because I don't know whether any of the justices have ever had a course in environmental law, but it tends to be where these cases go. The next one does the same thing, only it's about the Fifth Amendment ultimately, and also the 11th Amendment. It's about a pipeline, a very long natural gas pipeline that was to be constructed by PennEast. PennEast, if you notice, doesn't have the word state after it, or it's not a country. It's not a government. It's a private company. And so in this case, the question is whether the Natural Gas Act, which provides authority for eminent domain, can be exercised by a private company. So you may wonder, well, how do we get to that? Well, we get to that through the Natural Gas Act permitting the Federal Energy Regulatory Commission to condemn property for just these kinds of purposes, pipelines, transmission lines, and so on. And FERC has done that. Ordinarily, and most often on private land, not land owned by states, but also on federal land. But again, let me emphasize, not land owned by states. That's fairly rare. So here we have two levels of remove. First is that it involves condemning state land for a pipeline in Jersey. So New Jersey, they're the litigants here, the challengers here. And secondly, condemnation by not a government, a third party, a company that stands to benefit and pay pennies on the dollar for the value of the land. So this case goes, before the Supreme Court, and just, on June 29th, the very end of the last term, Justice Roberts in a 5-4 case writes the majority opinion. And he finds in favor of PennEast that this is authority PennEast can exercise. Why? Well, first of all, we have the Fifth Amendment that provides for compensation, nor shall the government take private property for public use without just compensation. And so as sort of an entryway there, it's a statutory construction case. Does the Natural Gas Act give FERC authority to condemn property? You may wonder, why am I not talking about PennEast yet? Well, because we're not there yet, but that's the first determination the court has to make, is whether Congress has that authority. And Justice Roberts, writing for the court, says yes. Congress can give authority to condemn to an agency. And the federal law gives that agency then authority to condemn property. The next question is, does it give authority for the agency to delegate that condemnation power to a third party? You may be thinking, oh, non-delegation doctrine? Well, that didn't come up. But the court finds that, yes, Congress can give condemnation power can permit agencies to delegate condemnation power to third parties like it did here. So that's checkbox number 2. So PennEast can exercise this power. And then there's this third one, which is, well, what about the states? Well, could FERC condemn state property under the Natural Gas Act? And Justice Roberts doesn't see anything in the law that suggests that it can't. It doesn't very often, but that doesn't mean that it can't. Which brings us to the third and final issue, which is whether, if FERC can condemn state property, whether this private company can with delegated authority from FERC. You know where this is going. The court says yes. And there are questions of sovereign immunity. Well, what does that do about the 11th Amendment? Well, Justice Roberts, writing for the majority, comes up with an interesting theory that the states have consented to condemnation actions under the Fifth Amendment based upon adoption of the Constitution. Did you get that? So signing on to the Constitution, ratifying the Constitution, is consent to being subject to even a civil kind of action by a third party like PennEast. So the 4 dissenters, their heads explode with all of this. And what I think is really interesting is that the dissenting opinion is written by, yes, none other than Judge Barrett. And if you have time, I commend it to you, because it isn't just a dissent. It doesn't just read like a dissent to me. It almost feels like, like when my 20-year-old daughter takes me on about whatever misconceptions I have about the modern world. It seems like Justice Roberts is receiving a lecture from Justice Barrett about sovereign immunity. And it's a textualized basis that, through beginning with the 11th Amendment, and I'll spare you of all those details, but Justice Barrett says, look, the way we've interpreted the 11th Amendment is to protect states who haven't provided their express consent or where Congress hasn't abrogated state sovereign immunity. But we protect them from these kinds of cases. That, the Seminole Indian tribe, Alden versus Maine, that's what those cases stand for. And so, that's what should carry the day in this case. And then ultimately, Justice Gorsuch also dissents separately, raising, I think, an interesting, another civil procedure issue, where he says, look, the 11th Amendment only applies to diversity cases, and this is a federal question case. So the majority went in the wrong direction. So that's a recap of the PennEast pipeline case. Next slide, please. So the next case is another, really simple case without any confusing language or issues involved. I'm just kidding. It's a really intricate case, the Holly Frontier Cheyenne case, but really it's about blending biofuels into the production process. So long story short, when refineries make derivatives of petroleum, there's gasoline and kerosene and distillates and so on. Well, in that process, you can inject or introduce biofuels, renewable fuels, they're called. And so 15 years ago or so, Congress made a law that required that. And it required major petroleum manufacturers to use a certain percentage of biofuels. And the percentage has gone up dramatically, roughly up about 10 to 15 times what it was 10 years ago. So it ensures a market for those who are producing renewable fuels. But it imposes a burden on small refineries. So small refineries may not have the same capacity as large refineries and often don't. So the small refineries are those that produce less than 75,000 barrels on average a day. So Congress provided for, and the Clean Air Act, provided for a period of time where the small refineries were exempt from this requirement to blend in renewable fuels. And then after that period expired in 2011, it permitted the small refineries to get extensions for up to 2 years at a time. And the language of the Clean Air Act permits small refineries to apply for an extension at any time. And that's what this case is about, is what does that at any time mean? Does that mean a small refinery could just turn away from the exemption for whatever reason, just not need it any longer, or have capacity that's more than 75,000 gallons a day, or just decide to deal with not blending in renewable fuels, but just not take advantage of the exemption, not apply for it. And years could go by. And then if it applies for it again, is it a continuation? Is it something that can, is it an extension of the prior exemption? So two analogies. First is the one that Justice Gorsuch uses in the majority opinion. He says, look, another part of this that's sort of fun. He's really talking about like being a teacher, being a professor or something, and having a student paper due. And if a student misses the deadline and it's due Friday, he uses this example. And the student then comes in on Monday and asks for an extension. That's still called an extension, even though over the weekend the deadline was missed, and that's it. So it's still called an extension. He said it's the same thing here. Small refineries didn't apply for an extension. Time goes on, but then it can, and because the law says at any time, and it's still an extension. But Justice Barrett, writing in dissent, yes, Justice Barrett writing in dissent says, no, that's crazy. That's not an extension. That's just a continuation of the deadline, if you will. Really what it's like is a hotel stay. Yes, using this analogy, that if you check into a hotel in January and stay for 2 nights, and then come back in June, you're not asking to extend your stay. You're having a new stay. And so under those circumstances, the Clean Air Act doesn't permit an extension of the prior exemption. So that's what this case turns on. And what's at stake is, lots and lots of extensions that have been granted to facilities that were no longer taking advantage of the exemption. So the Trump administration weighed in favor of the small refineries, not having to burn biofuels. And so the number of extensions to exemptions that was given out went from 8 in 2015 to 31 in 2018, because it's less expensive and so on. Well, with the change of administration, an interesting thing happened. The Biden administration wrote to the court and said, never mind. You don't need to defer to that earlier interpretation of the Clean Air Act and what extension means. We're not going to follow it. So please defer to that interpretation. Well, it doesn't work. Justice Gorsuch, in the 6-3 case, goes the other way, finding that the earlier determinations are not subject to Chevron deference or Skidmore deference or any deference at all. And it's really a case about statutory construction. And he's fixated on the language from the Clean Air Act that says that the exemptions can be extended at any time. So that's a victory for small refineries in this case. Next slide, please.
Okay, the next 2 cases we're going to talk about aren't really environmental cases, but we think they say something important about the direction the court may be going in a way that might affect some environmental cases. The Cedar Point Nursery case involves the question of what constitutes a taking, and in particular, a physical taking. In 1975, the California Agricultural Labor Relations Board had adopted a regulation that was actually modeled on federal law that allowed union organizers a limited right of access to be able to talk to farm workers on their breaks. The access was allowed for up to 3 hours per day for 120 days a year. And the nursery in California sued the California board, claiming that even a limited physical right of access to its private property constituted a per se taking, a physical taking under the Fifth Amendment. That would mean they wouldn't have to worry about using the old Penn Central balancing test to assess the reasonableness of the regulation and determining whether compensation should be paid. They lost in both the district court and in the Ninth Circuit, who said this is not a physical taking of property at all. And the Trump administration supported the nursery and said that you should rule that it's a physical taking. But just over a month after the Trump administration filed its brief in January, the Biden administration said that that brief no longer represents the views of the United States, or they sent a letter to the court disavowing the Trump brief. But what's significant about this case is, to me, it shows that when it comes to takings, the 6-3 conservative majority is all on board with the enterprise of doing more to protect private property rights. Chief Justice Roberts wrote the majority opinion, joined by the other 5 conservatives. And even though he has been cautious about moving the court too far right too quickly, when it comes to takings, this is the court that 2 years ago in the Nick case, 5-4, when Justice Ginsburg was still alive and there were 4 liberals on the court, overruled longstanding precedent in the Williamson County case to make it easier for property owners to bring takings claims in federal court by dispensing with the requirement that they first had to exhaust state remedies. And the Chief Justice Roberts, in his opinion, says it's not the temporary nature of the taking that makes the difference here. That might go to how much compensation should be awarded. It's the fact that you're allowing private parties to invade your private property. And so the right to exclude others from your property is being taken away when you are forced to grant physical access to the property. And that makes it a physical taking. Now, he tried to limit the reach of this opinion by saying that they're not talking about isolated physical invasions, which are best dealt with by trespass law, or physical invasions that are consistent with longstanding background principles of nuisance law, and that when it comes to government health and safety inspections, you still should be able to require property owners to require a right of access as a condition of receiving certain benefits. Justice Breyer, dissenting, joined by Justices Sotomayor and Kagan, said that the decision threatens to make many ordinary forms of regulation unusually complex or impractical. Now, Jimmy's going to talk about a case that really has civil procedure professors excited. Next slide.
It's so true. It really, Bob is so right. So the next case is the Ford Motor Company case. And just to orient you, again, you may be wondering, well, what does this have to do with the environment? It's not a pollution case. It's not a climate change case. It's not an emissions case. You may be thinking because it's Ford Motor Company. No, but it's a case that matters a lot for environmental cases in general, and specifically about climate cases. Let me try to explain. So this case, Ford Motor Company case, is really a case about Ford Explorer and Crown Victoria, 1996 Ford Explorer and a 1994 Crown Victoria. I've been in both, classic cars. And there were accidents that happened in one in Montana and the other in Minnesota. So these 2 Ford vehicles were involved in accidents. And, lawsuits resulted under state law, negligence and so on. And there's a question about personal jurisdiction. Yes, yay, personal jurisdiction. Here you go with civil procedure again. So not just personal jurisdiction, any kind, but specific personal jurisdiction, the best kind. And that asks the question as to whether the plaintiff's claims arise from or relate to the defendant's activities with a forum state. So that specific jurisdiction arise from or relate to. And if it does, if the plaintiff's claims do that, then we get into all that personal jurisdiction analysis that you remember so well from your favorite days in civil procedure, which I hope was every day, which is minimum context analysis, asking whether the defendant has purposefully availed itself of the privilege of doing business in the forum states, and if it has, if it's reasonable to expect the defendant to defend itself and so on. Yes, civil procedure nerd here, but it matters for climate change cases. The same kinds of issues can arise in private and public nuisance cases, cases brought by individuals and cases brought by states. The question is, can the state court exercise personal jurisdiction? So here's the link. In these cases, Ford argued that it can't. The states here couldn't exercise personal jurisdiction. Why? Well, Ford admitted that it had tons of dealerships and sold tons of cars for tons of years in Montana and Minnesota. So no problem there. But the Montana and Minnesota could not exercise personal jurisdiction because, next slide, please, Chandler, couldn't exercise personal jurisdiction because their contacts with the forum state weren't specific. That the injuries in the two cases, one was for the Explorer, it was a tire that blew out and somebody died, and the other was a horrible accident, two people going out on a fishing expedition, go ice fishing, and a snowplow was rear-ended and the passenger was injured. But Ford was sued, and Ford said, look, we didn't have anything to do with that. You know, we designed the car in Detroit, that's Michigan. We manufactured the cars outside of these states, in Canada and Tennessee and elsewhere. And the cars were also purchased in other states. So the cars were neither manufactured nor designed nor purchased in Montana or Minnesota. So therefore, the claims don't arise from or relate to our contacts with the forum states. So if you were waiting all this time for a unanimous opinion from the court, you were finally there. Well, kind of, it's an 8-0. Justice Barrett didn't participate. But there are some concurring opinions, but Justice Kagan, writing for the court, says, well, the claims both arise from and relate to both. Ultimately because Ford has so much contact with Montana, and so much contact with Minnesota, encouraging people to buy cars and having special cars designed, you know, for college teams and for the rest of it. Ford is so invested in these states that the claims then arise out of or relate to those contacts. There's Justice Alito, writing a concurring opinion, disagrees. He says he would keep the law just as it is. That he takes issue with Justice Kagan, in essence, turning this into a two-part analysis as to, you know, whether, you know, first the claims arise from, and secondly, whether they relate to the defendant's contacts with the forum state. And Justice Gorsuch and Thomas concur more or less along the same lines. Just have, you know, thinking that Justice Kagan has developed a new standard for personal jurisdiction analysis, which would both confuse me and make my day. Well, I should say confuse my students and make my day. But we see again the ascendant and the really important role of civil procedure in these cases. So the court the justices tend to really, you know, get into these kinds of issues. The other subject they tend to get into a lot again is water, cases about water, which brings us to our next case. And next slide, Bob.
Okay, well, actually, we made a switcheroo based on something that happened at 9:30 this morning. So next slide. The next slide's not about water, but
Okay.
This morning in the case of Biden versus Sierra Club, the Supreme Court granted, vacated, and remanded to dismiss the lower court judgments in the border wall cases. Now, I've seen some misreporting on this already that said that this was a blow to the Biden administration and they upheld the legality of Trump's use of federal funds to build the border wall. But that's really not the case. What happened, you'll recall, was Trump insisted that there be a huge appropriation so that he could build the border wall, and Congress refused to do so. In fact, it precipitated what's still the longest government shutdown in history. Trump then declared a national emergency, took funds that was in the Defense Department budget, or Department of Homeland Security, and used it to fund the border wall. he was sued by the Sierra Club. There were a variety of lawsuits, and a district judge held that the funds were being spent illegally. That was upheld by the Ninth Circuit, but the Supreme Court intervened and stayed those in a use of the shadow docket. We're probably not going to have time to talk about the shadow docket today, but it effectively allowed the Trump administration to keep building the wall and spending the funds, despite the fact that lower courts had ruled that it was illegal. Now, on January 20th, Biden takes office. He immediately revokes the declaration of national emergency, halts any construction of the border wall, and then tells the Supreme Court this is no longer a live controversy. What you should do is grant, vacate, and remand, which is exactly what they did. It wipes out the decisions arguably constraining the president's discretion on how he transfers funds. Next slide. The one environmental case that is on their docket for oral argument is Mississippi versus Tennessee. Next slide. This is the case. Oh, sorry, go back to that, I guess, even though the slides kind of messed up, and I hate it when you transfer slides from Keynote to PowerPoint, they bleed. But the oral argument in this case was fascinating today because it showed that the courts now kind of got down this new oral argument procedure. Mississippi in this case argues that the city of Memphis is sucking so much groundwater from an underground aquifer that it's creating a cone of depression. That means the aquifer is moving from being beneath Mississippi land to being beneath Tennessee land. Now, the special master in this case said there'd never been an equitable apportionment that says who should be entitled to how much use of the water between the two states. So he recommended that the case be dismissed and said that you could grant leave to Mississippi to mend its complaint and ask for equitable apportionment. So the real legal issue here is, do you need equitable apportionment of groundwater? It's really the first interstate dispute the courts heard in its original jurisdiction involving groundwater. And counsel for Mississippi essentially kept saying, but they're stealing our groundwater by making it move. And some of the justices pointed out, well, anytime you have a well, it's going to have some influence on how water flows through an aquifer. They seem quite unimpressed with that. And I think that was indicated by the fact that the major issue they spent a lot of time on is, should we grant leave to amend? Should we deny leave to amend the complaint? Or should we just say nothing about that? So now, cases on the horizon. Next slide. These are really, next slide, really the biggies. And these are the cert petitions involving the DC Circuit's decision striking down Trump's Affordable Clean Energy rule and ruling that their repeal of Obama's Clean Power Plan was illegal because it was based on a misinterpretation of the Clean Air Act. Of course, the Biden administration is not unhappy with that ruling that was handed down a day before the Trump administration left office, so it's not seeking cert in the Supreme Court, but a number of red states and fossil fuel interests are seeking cert. And the Biden administration has opposed cert, saying, we're not going to revive the Clean Power Plan. We're not going to revive the Affordable Clean Energy regulations that Trump promulgated. We're going to go back to the drawing board and come up with a completely new approach. So there's nothing to see here. Anything the Supreme Court did would be just an advisory opinion to tell EPA what they should and should not be doing in the future. The petitioners are saying, well, but that would be good. EPA needs this guidance. And you'll recall that before the Clean Power Plan was even finalized, the fossil fuel interests tried to get the DC Circuit to intervene and stop it. But as any first-year administrative law student would know, without final agency action, DC Circuit had no jurisdiction. When they did finally sue, that was used for the Supreme Court's unprecedented action of, even though the DC Circuit denied a stay of the Clean Power Plan, the Supreme Court intervened on a 5-4 vote on February 9th, 2016, and stayed the Clean Power Plan. So this morning, they did not deny cert, although it was discussed at the long conference a week ago. This morning, they did not grant cert. The one dissenter in the 2-1 decision by the DC Circuit is Judge Justin Walker, the newest and youngest member of the DC Circuit, who was a law clerk to Justice Kavanaugh. His big issue is the major questions doctrine, the notion that if a regulation's really big and really important and affects a whole lot of the economy, EPA shouldn't have authority to issue it unless Congress expressly said, we want you to do what EPA said that it wanted to do. So stay tuned on this, because if the court does grant it, I've been quoted as saying it would be a breathtaking act of judicial overreach. So next slide. Jimmy's going to talk about 2 preemption cases.
Yeah, so these, as Bob mentioned, you know, these are sort of breathtaking cases too, of a certain way of thinking about it. They're both about preemption. So one is out of California, the other is out of Ohio. Let me tell you about them. The first one is about the Federal Insecticide, Fungicide, and Rodenticide Act and Roundup. FIFRA, as you know and love it, it requires labeling to provide a warning about anything on a product that can be an endangerment to human health or the environment. It also prohibits states from requiring labels in addition to or different from that general requirement. So what did California do? Well, Prop 65. So Prop 65 requires that labels of chemicals that cause cancer, or the label declare if it has chemicals that cause cancer. California determines based upon various evidence and studies in other countries and how glyphosate, I'll get it, that glyphosate causes cancer. And so California requires that the label say that. Well, lo and behold, Mr. Hardiman contracts non-Hodgkin's lymphoma and brings a lawsuit against Monsanto, alleging that the glyphosate caused his cancer. So what happens? Well, it goes to a jury, and a jury awards compensatory damages of about $5.25 million and punitive damages of $75 million. So the court is concerned about the punitive damages part of it. That's not what this case is about, but it could have been. I mean, the court invoked procedural and substantive process on a remittiture motion and reduced that down to 20 million bucks. But that's not what this case is about. It's about preemption. So Monsanto argues that the state failure to warn claim that was brought by Mr. Hardiman was preempted by FIFRA, by that language that I mentioned earlier that says that states can't develop language that's different from or in addition to what's required by FIFRA. And the Ninth Circuit gets a hold of it. But in the meantime, after the jury award, the Trump administration, the Trump EPA, issues a general letter to those who have registered glyphosate, saying, that there can't be any additional labeling. That in fact, including additional warnings would be a mislabeling under FIFRA itself and would be illegal. So Monsanto takes that, puts it in its back pocket, and goes to the Ninth Circuit and says, this is preempted. It's preempted expressly by Congress, and if not, it's preempted impliedly. And in a 2-1 case, the Ninth Circuit disagrees, finding that the FIFRA doesn't preempt either expressly or impliedly the state failure to warn claim. There's no express preemption because there we look for some clear and convincing congressional statement, and that's lacking. And there's no impossibility or obstacle preemption, which is the third flavor of preemption, because complying with the state law is a means for complying with the federal law. They're not in conflict with each other. They complement each other. Next slide, please. Which then brings me to the next preemption case, which is the Volkswagen case. And you know this is an oldie but a goodie. it involves cheating, as they might say about emissions, and an emissions defeat device that Volkswagen was putting into its cars that it was otherwise advertising as being, so efficient with low emissions and so on. Well, this is a case initially brought by the Attorney General in Ohio. So this is a state claim, for tort law. And the question is whether the Clean Air Act preempts these state law claims. So the Ohio Supreme Court says no. It affirms the lower court decision that the Clean Air Act does not preempt these kinds of state law claims, even though the Clean Air Act reads that no state shall adopt or attempt to enforce a standard relating to control of emissions from new motor vehicles or engines. And I had to read that because I wanted you to hear the new part. So Ohio says, look, we're not doing that. We're talking about what happens after the cars are purchased. And Ford did a recall, so the cars weren't new any longer. And Ford lied about, I'm sorry, Ford, there we go. I was mixing up personal jurisdiction, but Volkswagen lied about what they did. They tampered with these emission control devices. And that's no longer doing something that controls emissions from new vehicles. So therefore, it's not preempted. The two quick things are, first, no express preemption for the same reasons as in the Hardeman case, because there's no clear congressional intent to preempt. And then the court goes into analysis of each flavor of implied preemption, that there's no field preemption, because Congress didn't mean to preempt actions brought by the state regarding tampering of used vehicles. There isn't any conflict preemption because you can still comply with the Clean Air Act requirements regarding new vehicles, or that bringing these separate tort actions doesn't do anything about, isn't in conflict with requirements for new vehicles. And lastly, there's not obstacle preemption or impossibility preemption because the common law cause of action go forward, notwithstanding the Clean Air Act requirements. So no preemption there. So these are cases that Bob and I think that it's a fairly decent chance that the Supreme Court will take a really hard look at these two preemption cases, primarily because they're really cases about, again, statutory construction and reading statutes plainly, which we see a penchant for, especially with the new makeup of the Supreme Court. Next slide, Bob, over to you. Thank you.
Thanks. Okay, so those are the cases. We're going to just briefly discuss, should Justice Breyer retire, and mention Biden's Supreme Court commission. A lot of people have been pushing Breyer to retire so that President Biden could have a nominee to the Supreme Court. Notice he's 10 years older than the other justices. Next slide. And these groups are actually, they've been having this truck circle the Supreme Court, urging him to retire. He's decided not to retire for now. The one thing I would argue is that because he's been on the court longer than any justice other than Clarence Thomas, he has real gravitas, particularly on issues like administrative law issues. He used to teach that and developed a real specialty in it. When he says that a decision on a shadow docket order is very, very, very wrong, it carries a lot of weight. Now, President Biden, next slide, has pledged that his first nominee to the court will be an African-American woman. And in fact, when he made Merrick Garland Attorney General, DC District Court Judge Ketanji Brown Jackson was nominated by President Biden to the DC Circuit, and she's now been confirmed. Next slide. And President Biden, by executive order last April, created a 36-member commission to study whether reform should be made with respect to the Supreme Court. During the campaign, he was always asked, would you be willing to pack the court? Democrats, of course, were quite outraged by the hypocrisy of Senator McConnell when he was Senate Majority Leader, blocking confirmation of Merrick Garland to the Supreme Court after Obama had nominated him for almost an entire year. It was in February when Justice Scalia died in March of 2016 that Merrick Garland was nominated by President Obama, didn't get a hearing at all. And then the ostensible reason was because it was an election year. But then Justice Ginsburg dies in September 2020, not only an election year, early voting had already started for president. And yet they rushed through Judge Amy Coney Barrett, who was confirmed in 30 days, even while the election was taking place. And of course, Article 3, Section 1 of the Constitution says nothing about how many members the court should have. That can be changed simply by legislation. So if the Democrats wanted to and continued to hold majorities, they could, presumably, but for the filibuster, be able to add justices to the Supreme Court. Now, of course, it took eliminating the filibuster for Brett Kavanaugh and Neil Gorsuch and Amy Coney Barrett. Previously, the filibuster had been eliminated for courts of appeals nominations when McConnell was trying to block all those, but it was agreed that they still would have it available for the Supreme Court. But then when a vacancy arose and Gorsuch was nominated, they abolished the filibuster. So the Democrats, if they wanted to, could, play similar hardball. This commission is studying things like expanding the court, term limits, its role in the constitutional system. As Article 3, Section 1 is written, it says the judges of both the Supreme Court and inferior courts shall hold their offices during good behavior, and their compensation shall not be diminished. Some proposals are being made for term limits, and it's viewed that this would be for future justices. They'd have 18-year terms, and then every 2 years, like clockwork, one would have to retire, and the presidents in the future would be guaranteed to each have 2 Supreme Court nominations each term that they serve. And this seems to be, next slide, getting the most support from the commission. It's held a couple of meetings. It has from 180 days after its first meeting on May 19th, it's supposed to wrap up its work. It's emphasizing that it's not being charged with making recommendations, but rather just to flesh out some of these issues. Next slide. Now, of course, the big controversy that you're hearing about today is over this shadow docket. Next slide. The very term shadow docket, which had been used for years, is one that's being criticized. Justice Alito, in his speech last Thursday, said that it was an insidious effort to attack the court and trying to intimidate the justices, when actually what the term refers to is the court's order list. And these are things decided without full briefing and oral argument. And during the 2 previous administrations, 16 years of Bush and Obama, only 8 times did the federal government ask for emergency action by the Supreme Court. But during the Trump administration, 41 times it was asked for emergency action by the Supreme Court, and the court intervened quite frequently. And in fact, just in the last term that concluded today, the court granted 20 applications for emergency relief, including 7 emergency injunctions against state laws, including laws designed to protect the public during the pandemic, where it said they violate the First Amendment. These cases are not fully briefed or argued. It's sort of the gut reaction of the justices. And as Professor Steve Laddick of the University of Texas Law School has documented, in almost all these cases, it's the 6 or 5 justice conservative majority, with sometimes Chief Justice Roberts joining the liberals, that are granting these orders. And their refusal to grant the Biden administration relief from a lower court injunction with respect to immigration policy, and the refusal to intervene to block the Texas abortion law, have now made the shadow docket quite controversial. Next slide. So the very fact that Justice Alito would speak out and sort of, I think, very unfairly characterize those who are raising these issues as trying to intimidate the Supreme Court and say there's something sinister about calling it a shadow docket when the term was invented in a 2015 law review article written by one of Chief Justice Roberts' former clerks, is really going too far. But I think what you see on the court now is they're going to be at the center of a lot of controversies over abortion and gun rights. Chief Justice Roberts has not wanted the court to move too fast in a conservative direction, but the super conservative 6-3 majority that's on the court now has at least 3 justices, Alito, Thomas, and Gorsuch, that are willing to go gung-ho in pushing the court further to the right. And it will sort of depend on whether Barrett, Kavanaugh, and the Chief Justice continue to play a more moderating influence, because really the court's legitimacy is at stake when the public loses confidence in them as a neutral legal institution and considers them more like a legislature. Thank you.
Gentlemen, we're about out of time. We do have one question I'd like you to address in chat. How do we square the court's strong defense of private property under the Takings Clause in Cedar Point Nursery with allowing private seizure of land as delegated by FERC in the FERC case?
Well, that's what you're seeing more frequently now, is sometimes these issues come back in conflict with one another. And I'd refer you back to the Arco versus Christian case from a term ago, where it was a property rights case for the locals who wanted to be able to sue the smelter owner for the cleanup of the Superfund site. And what you saw in that case, I think, was really telling. 2 conservative legal foundations that almost always support big business, the Pacific Legal Foundation and the Washington Legal Foundation, took diametrically opposed positions in amicus briefs. The Pacific Legal Foundation said, this is an issue of federalism and property rights. Therefore, you should hold that CERCLA does not preempt the ability of Montana state courts to award restoration damages to property owners whose property's been polluted. Washington Legal Foundation was all gung-ho, whatever Arco wants in that case. So I think you're going to see some strange bedfellows in the future, and it's going to be hard for the courts. Always had a hard time explaining how to reconcile the Takings Clause with the 11th Amendment, which is what came up in Penn East. And the argument that's been made is, well, the Takings Clause predates the the 14th Amendment was passed after the 11th Amendment, and therefore the application of the Takings Clause to the states was able to qualify the 11th Amendment immunity that states otherwise would have to not pay judgments to property owners. So go figure. Excellent question.
Excellent. Well, unfortunately, we are out of time. Apologies, we were not able to answer more questions, but I just want to say thank you so much to our audience for joining us today and for the many thought-provoking questions we did receive. We hope you'll continue to watch this space in the years ahead and join us next year for the 2022 Annual Supreme Court Review and Preview. And finally, an enormous thank you to our outstanding panelists. I thought this session was absolutely fascinating. I certainly learned a lot and really appreciated the really to the final minute updates that we got this morning. I really loved that and enjoyed that. Just appreciate your many contributions to today's program. And just want to say thank you all so much. Please take care and stay safe. Thank you, everyone.